Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Jason J. Ambrosio, decided February 17, 2026. Opinion. Canataro J. Defendant was convicted, upon a jury verdict, of driving while ability impaired by a drug, Vehicle and Traffic Law, Section 1192, and driving while ability impaired by the combined influence of drugs, Vehicle and Traffic Law, Section 1192, 4A. On this appeal, defendant argues that his trial counsel was ineffective for failing to request a jury charge defining impairment by drugs consistent with the Third Department's decision in People v. Caden N, rather than the model jury instructions and this court's decision in People v. Cruz. We disagree. In People v. Cruz, this court distinguished the crime of driving while ability impaired by alcohol, Vehicle and Traffic Law, Section 1192, from the crime of driving while intoxicated by alcohol, Vehicle and Traffic Law, Section 1192, by construing the statutory terms impaired and intoxicated according to their commonly understood meanings. Regarding impairment, we explained that the question is whether, by voluntarily consuming alcohol, the particular defendant has actually impaired to any extent the physical and mental abilities which he is expected to possess in order to operate a vehicle as a reasonable and prudent driver. 4 decades later, in Caden N, the defendant was convicted of vehicular manslaughter on the theory that he caused death while his ability to operate a motor vehicle was impaired by a drug. See Penal Law Sections 125.13, 125.12, Vehicle and Traffic Law Section 1192. Although both parties agreed on appeal that Cruz's definition of impairment by alcohol supplied the relevant definition of impairment for purposes of the vehicular manslaughter charge, the Third Department determined for itself that a different standard applied, holding that, in the context of assessing whether a person has committed the crime of vehicular manslaughter in the second degree, impairment by a drug requires the same degree of impairment as would be necessary to sustain a conviction of driving while intoxicated by alcohol under Cruz. Namely, the people must prove that such motorist was incapable of employing the physical and mental abilities which a person is expected to possess in order to operate a vehicle as a reasonable and prudent driver. Defendant in this case was charged with 2 counts of driving while ability impaired by a drug and 1 count of driving while ability impaired by a combination of drugs. See Vehicle and Traffic Law, Section 1192 and 4A, based on his operation of a vehicle after having ingested both marijuana and buprenorphine Suboxone. The trial was held within the Third Department approximately 1 year after Caden N. During the charge conference, defense counsel requested the standard jury instructions for the charged offenses. The trial court accordingly instructed the jury on the law using the model criminal jury instructions for subsections 1192 and 4A, which at the time of defendant's trial employed a definition of impairment by drugs that paralleled Cruz's definition of impairment by alcohol. See CJI 2D NY, Vehicle and Traffic Law, Section 1192 and 4A, Rev. January 2008. Defendant appealed from the resulting judgment of conviction, arguing that his counsel was ineffective for failing to request a jury charge on the meaning of impairment by drugs based on Caden N. The Third Department affirmed, reasoning that, by its own express language, Caden N applied only to the crime of vehicular manslaughter and not to the underlying crimes of driving while ability impaired by drugs or by a combination thereof. Even the dissenting justice who authored Caden N. rejected defendant's ineffective assistance claim, stating that it is difficult to characterize Caden N. as so clear-cut that counsel's failure to request a charge premised on Caden N. was constitutionally ineffective. To prevail on a claim of ineffective assistance of counsel under our state constitution, a defendant must establish that counsel failed to provide meaningful representation and thus deprived defendant of a fair trial. People v. Watkins, quoting People v. Clark. This standard requires an objective assessment of counsel's representation as a whole in light of the evidence, the law, and the circumstances at the time of the representation. See Watkins, People v. Benevento, People v. Baldi. A single error may qualify as ineffective assistance, but only when the error is sufficiently egregious and prejudicial as to compromise a defendant's right to a fair trial. Watkins, quoting People v. Caban. Such cases are rare and typically involve the failure to raise a defense that was clear-cut and completely dispositive. People v. Turner, Accord Watkins, People v. Sanger. See also People v. Burrell, counsel not ineffective for failing to raise issue of uncertain efficacy. Consequently, counsel is not ineffective when the success of the argument the defendant claims should have been made by counsel depended on the resolution of novel questions, or when, at the time of the defendant's trial, there was no clear appellate authority supporting the argument. People v. Hayward. Indeed, we have on occasion rejected ineffective assistance challenges when it is clear to the court that the objection or contention that was omitted would not have been a winning argument, leading to appellate reversal of a judgment of conviction and sentence. People v. Keshner. The defendant bears the burden of showing ineffectiveness. Watkins. Defendant argues that Caden N. established a clear right within the Third Department to a jury charge in Vehicle and Traffic Law, Section 1192 4 and 4A cases that defines impairment by drugs consistent with the higher standard of intoxication by alcohol from Cruz. But as the Third Department itself explained below, the holding and reasoning of Caden N. were carefully limited to the statutory scheme for vehicular manslaughter. And at the time of defendant's trial, no court in this state had extended the reasoning of Caden N. to charges under Vehicle and Traffic Law, Section 1192 4 or 4A. Further, the model jury instructions, on which this court has advised both counsel and trial courts to rely, e.g. People v. J.L., People v. Cubino, were not revised to account for Caden N. until December 2021, 3 months after defendant's trial. Even then, the CJI committee advised in an explanatory note that Caden N. did not explicitly discuss whether the standard for impairment for purposes of a prosecution for vehicular manslaughter in the second degree was also the standard to be applied in a prosecution for only VTL 1192-4. And that, until an appellate court decides otherwise, a trial court may decide to apply Caden N.'s definition of impairment for a vehicular manslaughter or assault charge, and the impaired to any extent definition for a VTL driving while impaired by the use of a drug or combination of substances. Under these circumstances, although trial counsel certainly could have argued that the Caden N. definition of impairment should be extended to Vehicle and Traffic Law Section 1192-4 and 4A, the mistake, if it was one, was not the sort of egregious and prejudicial error that amounts to a deprivation of the constitutional right to counsel. See People v. Thompson. Accord People v. Blake. See also Watkins. Finally, it is worth mentioning that in light of our decision today in People v. Dondorfer 2026 NY Slip Op 00823, defendant would not be entitled to a Caden N charge if a new trial were ordered. Accordingly, the order of the Appellate Division should be affirmed. Order affirmed. Chief Judge Wilson and Judges Garcia, Singas, Troutman, and Holligan concur. Judge Rivera concurs in result in an opinion. Decided February 17, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.